Welcome to this week's edition of It's Chaile Time. Today we're going to be dealing with a case law review on a very recent case law that came out from the Labour Court that deals with intoxication or having alcohol or drugs in your system while pitching up for duty. A bit of a contentious issue. Often you will have employees either pitching up at work under the influence of alcohol or some kind of drug, or they will just pitch up. They are not under the influence of any intoxicating substance, but it may be that they will fail a breathalyzer test. And how do you deal with this? Can we actually dismiss employees for just pitching up for work? Maybe they had a drink or two the previous evening and there are still alcohol in their blood, but they're not intoxicated. They're not necessarily under the influence of alcohol to the extent whereby they cannot adhere to their contractual obligations and their duties. Keeping in mind that the first step to this question is that an employer has a responsibility in terms of the Health and Safety Act to reasonably create a safe work environment for all staff and their clients and so forth. So being under the influence of alcohol while at work can have detrimental consequences, especially if you look at the context of some employers whereby they may be working with dangerous chemicals, machinery, explosive like on mines. And if you allow an employee under the influence of alcohol to actually gain access to the workplace, it can have severe consequences and severely prejudice the employer and all the stakeholders and the people involved. Now, a very recent case law came out at the Labour Court and the case law is Samancor Chrome in their Western Chrome Mines versus Rikus Ernest Willemsen. Very recent, I think it was in May this year, May 2023 if I'm not mistaken, that this case law came out whereby remarkably an employee who was found positive for being tested for alcohol by a breathalyzer at their mines and subsequently being dismissed, just a bit in a nutshell in terms of the context of the story, went to the CCMA. They found that the dismissal was unfair, and upon review the employer was not successful in having the arbitration reward overturned and being set aside by the Labour Court. Basically, the dismissal was ruled to be unfair. And since then, oh man, in the HR fraternity it's been chaos almost, whereby people now believe that you cannot use breathalyzer test anymore to test staff, and if they fail a breathalyzer test, then you can no longer take disciplinary action against the staff. I think it is important. We're going to go through it now very quickly, but I think it is important to understand that every case is judged on its own merits. There are particular circumstances around each and every case, and it is not true that employers cannot use breathalyzer test in order to test the level of intoxication of employees of any alcohol or any intoxicating substance. But the first step, remember, it's always important to understand in terms of the Health and Safety Act, an employer has a duty to create a reasonable, safe working environment for its staff and all stakeholders that may come on the premises and so forth. I'm sure you can understand that if you work with chemicals or explosive devices or heavy machinery, that people can be injured, they can severely be harmed or even be killed. And obviously the prejudice on the employer is enormous when it comes to the health and safety of its employees. So, Samancor Chrome versus Rikus Ernest Willemsen. The second point is quite important, is that the company must have a policy. Many companies have a zero tolerance policy. Is it reasonable? Well, one will have to look at the context and the circumstances, I suppose. I must say, to a large extent, because of the requirements of the Health and Safety Act, it is generally not allowed for an employee to be intoxicated or you see, I'm playing with my words here, intoxication versus just arriving at work with having alcohol in your system, because there is a bit of a difference. We'll touch base on it in a moment. But at the end of the day, an employer must create a reasonable, safe working environment. And I have seen, even in your environments that on the face of it seems to be less threatening, like for instance in a restaurant, I've seen people under influence chasing each other around with knives, wanting to stab each other. You know, you can be very prone to conflict or being assaulting other fellow colleagues if you had a bit of a dop, you know, maybe during shift or even before work, you know. So the consequences and the prejudice is quite severe. But okay, let's just touch on this difference quickly. And employers typically charge employees for either one of the following or maybe both. The one issue is just arriving at work having alcohol in your system. Is it reasonable to dismiss an employee? You know, it is one of those sensitive matters for me personally because, you know, I've been dealing with representing companies at the CCMA probably for 15 odd years, and by far the most, if an employee picks up under the or having alcohol in the system, and there is a policy and there's a level of danger to his work context, employees don't typically win these kind of cases. A dismissal is, if you are found guilty in a disciplinary hearing, a dismissal is typically found to be substantively fair. Obviously, you know, we presume then that the employee was found guilty in a disciplinary hearing process that complies with Schedule 8.4 of the Labour Relations Act dealing with misconduct. But that is just if an employee picks up at work and having alcohol in his system. Whether a person must be dismissed, well, I suppose that depends on the circumstances and actually your work and what kind of environment you're operating in. But I do want to warn employers not to over easily simply dismiss people. You know, because if there's no real prejudice, then maybe a dismissal in the first instance may be too harsh. But anyway, then there's a second issue, the issue of actually being under the influence of alcohol. Now, that is where we talk about the sobriety of the employee itself. In other words, his abilities are impaired to the extent whereby he cannot adhere to his contractual obligations. In other words, he can't actually work. A typical example will be, for instance, you know, when you see somebody's demeanor, slur of speech, you know, or his eyes are bloodshot, then you, and also if he conducts himself out of character, what your HR people typically will do is they will get their little check sheet, a sobriety tick sheet, and start ticking the boxes to see, you know, if he is fit for duty or not. Now, if you are under the influence of alcohol, well, that's a bit of a different scenario. I doubt if an employee will easily win such a case at the CCMA if you were found guilty for being actually under the influence, because, as I've said, I've seen people stabbing each other. I've literally seen people in machinery standing on machines and putting there's one guy put his foot inside the machine and it literally broke his foot off. You know, so if you're working in a dangerous environment and you are found guilty for being under the influence of alcohol, you will probably not survive CCMA. But anyway, so okay, let's just go through this case quickly and see what we can learn from this case. First of all, some Mancor, they've got their policies in place, okay? There is zero tolerance policy on alcohol and drugs. That means you cannot come to work and have any alcohol in your system, 0%, okay? And they also do breathalyzer tests. They've got security there. That's, in terms of this case study, there are thousands of people that come daily through the doors, so they test all of them, it seems. Secondly, that disciplinary action will be taken against any employee with a positive alcohol or drug reading, which may include a dismissal even on a first offense. So that is the actual policy of Samancor. So keep in mind here, they're not necessarily saying here that it must only be found that you were actually intoxicated. With other words, under the influence of alcohol. They are saying, if you just pitch up for work, having not a zero reading of alcohol in your system, that's it, okay? You'll be subjected to a disciplinary process and you will most likely be dismissed. Okay, so the findings, what happened in this case? This employee was dismissed on the 22nd of February 2019 for having tested positive for alcohol in his system. A security officer testified at arbitration that the employee arrived at work and he was tested. He was quite surprised when the test of the breathalyzer test came back positive, because he said that he did not drink on that day nor on the previous evening, so he was quite surprised. So they retested him, and again the test returned a positive result. Again alarmed, he still objected and said, but listen, this cannot be. So they went to take another breathalyzer machine, a completely different apparatus, and they tested him again, and once again he was found positive, having a positive result in terms of his alcohol content. So interesting is this employee then went to his doctor, and they did a blood test on him, and they sent it to the Empath laboratories, and they were found that the results was that it was negative. He didn't have any alcohol in his blood. Now this is a bit of an issue now. Who do you believe? Who do you trust? The breathalyzer test that was done with 2 different machines, 3 results showing positive, but the blood test show negative. And this is the crux of the situation. Here you have 2 situations in terms of evidence now. Breathalyzer test versus a blood test, okay? The employee was quite shocked. He actually had an expert witness arriving to defend him. And even in arbitration, the pathologist stated that the blood test is much more reliable. You must remember this word, reliability. We are starting to touch on the laws of evidence here a bit now, okay? The blood tests are more reliable than the breathalyzer test. Now, according to this expert witness, he stated that under certain conditions, a breathalyzer test can actually give you a false positive. And he's of the opinion that that is what happened here. And he gave some examples. For instance, if a person didn't eat for 8 hours, then it may render a false positive. Or if somebody ate food with yeast in it, it can also render a false positive. And this is now where the issue of reliability comes in. In a nutshell, all evidence is admissible, okay? But not all evidence will carry equal weighting. For instance, and this is a bit of a different subject now, people say you can't submit hearsay evidence in hearing. Of course you can submit hearsay evidence. Whether the arbitrator will put any weight on that evidence, well, that's to be seen. But in this case, you had the breathalyzer test and the blood test. From a reliability perspective, the commissioner accepted that the blood test had more weighting attached to it from a reliability perspective, and accepted the blood test result above and over that of the breathalyzer test. So, but interesting is in this case, and the Labour Court actually highlighted this fact, that the employer didn't have their own expert witness to come and rebut that of the pathologist. At the end of the day, a commissioner make a decision based on what's before them. So before you now go and say, listen, an employer can never use a breathalyzer test again. That is not the truth. Every case judged on its own merits. If they had their own expert witness, who know what the result would have been in terms of this dispute, okay? But anyway, so at arbitration, the company, Semancor, lost the case. Commissioner found that it was an unfair dismissal. So they went on a review. And basically, Semancor, the main argument in the main was the following. On review, Semancor argued that the commissioner committed a gross irregularity in that his findings was based on whether the employee was intoxicated or not. So they are saying, but listen, Mr. Commissioner, your findings should not have been whether the employee was intoxicated, with other words, unfit to perform his contractual obligations and duties, but only whether he breached the company's zero tolerance policy by having alcohol in his blood, okay? They then also further argued, Semancor, but listen, okay, there were 3 tests done by the breathalyzer test, okay? Surely on the balance of probabilities, that sort of outweigh the blood test. Okay. The commissioner at the end of the day argued, and they also, Semancor also argued, but listen, how is it possible of all the thousands of people that came, the false negatives or the false positive was only occurring with this employee? Then the court felt, but listen, if that is the case, the problem is Semancor did not call or submit into evidence any other of the other blood results, the test results of any other employee, whether it was positive, negative, and the circumstances in terms of who ate food with yeast, like bread for instance, or who didn't eat for like 8 hours. So it's just an empty argument. There's no evidence presented. Now, the thing with review applications is this: you cannot nitpick mistakes made by, or alleged mistakes made by a commissioner. It's not a tick box approach. Oh, that is right and this is wrong, this is wrong, this is wrong. No, it is whether, if there are any irregularities committed by the commissioner, whether in the main it renders the award unreasonable or not. So given the fact that Samancor did not produce their own expert witness to rebut that of the pathologist, and also they didn't provide any other evidence in terms of comparison results with other employees being tested, the commissioner can only go by the decision and the evidence in front of him, which is basically a blood test that showed that the result was negative. Now, I think it's important to understand in this case is primarily not about whether you can use breathalyzer tests or not, or in a way whether a blood test outweigh that of a breathalyzer test, okay? It is really about whether at the end of the day, based on that case and what was submitted before the chairperson, if based on the balance of probability the employee is guilty or not. So you'll find that, okay, maybe company X tomorrow do a test on an employee only using a breathalyzer test, but that's the only evidence submitted. Well, then you're still going to win your case as an employer, because on the probabilities, you're guilty. So it is not about, this case is not about the breathalyzer test. It's not about the blood test. It's about, at the end of the day, there were evidence submitted that was more reliable and in favor of the employee, which the decision makers did not take into consideration. And that is what it's all about. So, but, you know, I do advise that it is a bit of a game changer still. I will still advise employers now, in lieu of this judgment, that don't overly depend only on breathalyzer tests now. And the reason being is twofold. Number one is, if you take into consideration the skill of employees and their experience and the costs associated with replacing them and retraining new staff, just the fact that somebody on the face of it, or there's prima facie evidence that the person is guilty, doesn't mean you must necessarily automatically just dismiss people. It's costly for employers. They lose money, they lose skill, experience, and you don't want to arbitrarily dismiss an employee if he's not actually guilty. So in that context, I suppose, it's probably wise that if an employee fails a breathalyzer test, maybe test him 2 or 3 times, yes, but then also send him for a blood test. And I'm not saying an employer must now pay for the blood test. Send him, say, listen, go to your doctor and go get a blood test, okay? Because you don't want to unnecessarily just dismiss staff. And secondly, our labor dispute system, you know, a few years ago, the courts evolved this concept of de novo, meaning arbitration is new. The last thing you want now is, if you're an employer, you've got a breathalyzer test as evidence, submit it and you can get away with it. And who knows, at arbitration, this employee pitch up with a blood test. The commissioner is going to take it into evidence, take it into consideration. Yeah, you may say it wasn't available at that time, but you know what? With arbitration being de novo, what happened at the time is not the only consideration, you know. They will take that into consideration now too. So it is probably better to get a medical, a blood test done as well, especially once an employee has been found guilty and there may be a dismissal on the cards. Just make 100% sure. So, okay, that is for this week. We are focusing on the cases a bit. So, see you next week on It's Chaile Time. And don't forget to subscribe and to like.